From KSAT 12, Good Morning San Antonio starts right now.
And right now on GMSA at 9, we are waiting on closing arguments in the trial of former Minneapolis police officer charged in the death of George Floyd to begin in just a few minutes.
And we are standing by for a special report from ABC News. For now, welcome. It is Monday. It is April 19th.
So we are going to get to some news, and we're going to start with the 9 at 9 right off the bat.
Closing arguments will take place today in the trial of former Minneapolis police officer Derek Chauvin, who's charged with killing George Floyd. The jury's verdict could come this week.
Police have arrested the former sheriff's deputy suspected of shooting and killing 3 people in Austin yesterday afternoon. 41-year-old Stephen Nicholas Broderick was found this morning between Manor and Elgin, east of Austin.
Authorities in Wisconsin arrested a person of interest in connection with the shooting that left 3 dead and at least 2 more injured at a Kenosha County tavern. The sheriff's department said the person in custody will be charged with at least 1 count of first-degree homicide.
Today marks the somber 26th anniversary of the bombing of the Murrah Federal Building in Oklahoma that killed 168 people. A remembrance ceremony will take place at the site where the building once stood.
Today marks President Joe Biden's deadline for all U.S. adults to become eligible to receive a COVID-19 vaccine. More than half of U.S. adults have now had at least 1 dose of that vaccine.
Also today, the Supreme Court will hear an appeal in a 2015 case that could impact the status of hundreds of thousands of immigrants in the U.S. The dispute is whether those who receive temporary protected status are eligible to apply for green cards, even if they initially entered the country illegally.
Early voting begins today in San Antonio ahead of the May 1st city election. On the ballot are the candidates for mayor and 10 city council seats, plus 2 propositions.
NASA's helicopter successfully completed its first flight on Mars this morning. Ingenuity made history as the first aircraft to achieve powered, controlled flight on another planet.
Luke Bryan won Entertainer of the Year at last night's Academy of Country Music Awards. Maren Morris won 2 honors, including Song of the Year. And Miranda Lambert performed 3 times and held on to her record as the most decorated winner in AMC history. And that's today's 9 at 9. So we were expecting some sprinkles today, but the sun's kind of peeking out right now.
Wow. Okay. Sprinkles are gone.
Man, you guys are excited about it. Hey, listen, there are a few sprinkles out there. We are seeing some sun, too. It's going to be off and on cloud cover today. All in all, a pretty nice day. We had a great weekend, right? I mean, temperatures were very comfortable. We're starting off that way again this morning with temperatures in the 50s for the most part. Let's look at the radar, actually, and I'll show you what's going on there. We have some showers working through. Most everything is really light. Those are the sprinkles I'm talking about. Maybe around Bandera, you can see a very, very quick shower, but we're really dry at the surface. So a lot of this is evaporating before it's reaching the ground. Temperatures, 59 at the airport, 53 Kerrville, 60 Hondo, 58 in Uvalde, 61 Carrizo Springs. Pollen count is in. Good news, mold is down in the moderate category, so is oak. Those numbers both down from where they were yesterday. And our forecast today, 10% chance rain, that's it. Temperatures up around 74. For your highs, southeasterly winds 5 to 10 miles per hour. Guys.
Learn to temper our excitement when it comes to rain
and sprinkles.
Yes. You can see the roads are looking pretty good, though. That's not bad. The traffic is moving right along.
Yeah, looks good. And top stories we are following today, the final bargaining session between the City of San Antonio and the police union regarding contract negotiations is scheduled for this morning.
The biggest issue on the table is the appeals process for fired officers. The city wants an arbitrator to give more weight to the chief's decision to fire an officer, while the union wants its members to be able to continue to challenge what they think are unfair firings.
Well, today is the last scheduled session. Both sides could agree to go beyond that. The meeting starts at 10 a.m. and we will have updates in our later newscasts.
Election day weeks away, but you can get a head start on casting your ballot as early voting begins today.
Registered voters will decide on several key races for the school and city election. That includes San Antonio mayor, 10 city council seats, along with 2 propositions. Voters will need a valid form of identification when they get there. Polling sites will be open from 8 a.m. to 6 p.m. Monday through Friday, but hours will extend on Saturday until 8 p.m. Polling sites are closed on Sunday.
Early voting ends April 27th, and Election Day is May 1st. You can head over to our website, KSAT.com. If you're looking for some more information, we got plenty of it for you.
And the COVID-19 vaccine is becoming more available here in the Alamo City.
Max Massey now joins us live from Wonderland of the Americas Mall, where people can now just walk up and get a shot. Max, how does that work and how does it look out there? A lot of folks there yet?
Good morning, guys. It opened at 8 a.m. We've seen a lot of people walk through these lines, get their shot, and then get out. It is a fast, efficient, and frankly, an easy process. We're joined here with Bill from University Health. So what is the reason for all this availability?
Well, I think what's happened is vaccines are becoming readily available at more locations. So people have booked these appointments 2 to 3 weeks in advance, but they ended up getting them at another location. So what we've done to offset that is last week we started with a limited amount of walk-ins, and we're expanding that this week to offset those no-shows. So our hours we're running at Wonderland Mall are from 8 in the morning till 8 at night, and then we're also doing the same thing at St. Philip's College in the library from 8 to 5.
All right, Bill. So because people didn't show up, the no-shows mean walk-in availabilities for a lot of people.
Exactly. Now, folks can still go online and book their appointment if they want a little more flexibility to their schedule, where they know that they got an appointment at a specific time. But on the offside of that is you're more than welcome to just show up at either of our locations.
All right, so you don't even need an appointment. People are really running out of excuses not to get the vaccine. Now, there are some people out there who are a little hesitant after the Johnson & Johnson news. What would you say to them?
You know, I would put that in perspective. If you look at that, that was 6 incidents out of millions upon millions. So I would not let that fear factor intimidate you or even change your mind. You know, there's been so many success stories, and we are shooting Pfizer and Pfizer. And there's been so many success stories, and side effects have really been limited in all the vaccines that are out there.
All right, Bill, thank you so much. Time, one more time for us?
You bet.
What are the times for today?
Today, 8 in the morning to 8 p.m. at Wonderland Mall, and 8 in the morning to 5 p.m. at St. Philip's College in the library.
All right, guys. And if you have any questions, we're going to have all these answers, so much more for you. Just head to KSAT.com. Guys, back to you.
Max, thank you very much. A lot of folks just moving through that line pretty quick.
Yeah, I'm glad to see that it's moving very, very fast, very organized out there.
Speaking of moving,
yes,
birds move north to south. They migrate. I did not realize, a lot of folks may not have realized, that the airspace over Texas is full of migrating birds, like millions of them. And
then there's a way that you can help them out.
Yeah, apparently some of them are
turning off the lights.
Yeah.
Yeah.
Getting killed on their migration back and forth. So
let's help out the birds. Turn off the lights. According to an article we have on KSAT.com, it says bird experts say that the U.S. bird population is declining rapidly, and here's how you can help. Texas Parks and Wildlife says that businesses and homeowners around the state can help migrant birds with the simple step, turning off your lights.
So the birds are both attracted to and easily disoriented by excess light pollution in urban areas. So that's why you turned off the lights. You know, even in the Rio Grande Valley alone, Texas A&M University found that nature tourism, which is dominated by bird watching, contributes $300 million to the economy, and that's why we want to protect these birds and turn the lights out.
Yeah, according to the department, the state is globally important for birds. 1 of every 3 birds migrating through the U.S. in spring, and 1 out of every 4 birds migrating through the U.S. in the fall, or nearly 2 billion birds pass through Texas. So if you want to make a big difference again for future generations of birds, it says you could start by turning off all non-essential nighttime lighting on buildings and other structures from 11 p.m. to 6 a.m.
Yeah, a lot of businesses leave lights on, especially outside. So, you know, if you feel it's safe, turn your lights out and save a bird.
Yeah, we'll see how many businesses start following the trend, and then maybe it'll help out a little bit.
I wonder what all those street lights do for them.
What? I wouldn't do that.
I don't know.
I think we need those.
Just wondering what would happen.
It's scary.
907, 62 degrees.
And we're still waiting for the closing arguments in the trial of former Minneapolis police officer Derek Chauvin to begin. So we're going to take a look at that live as soon as that starts.
And as we head to break, here's a look at the stock market. Ooh, it's Monday. Ouch. That hurts.
Saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proven by circumstantial evidence when its existence can be reasonably inferred from other facts proven in the case. For example, if a person watches deer crossing a snow-covered field, the person has direct evidence of deer walking in the field because the person sees it. If the person does not see deer but finds deer tracks in the snow, the deer tracks are circumstantial evidence that deer walked in the field because that factual conclusion can reasonably be inferred from the tracks found in the snow. Now, attorneys are officers of the court. It is their duty to make objections they think proper and to argue their client's cause. However, the arguments or other remarks of an attorney are not evidence. If the attorneys or I have made or should make any statement as to what the evidence is that differs from your recollection of the evidence, you should disregard the statement and rely solely on your own memory. If an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement. The state has brought 3 charges, or counts, against the defendant. Each count charges a separate and distinct offense. You must consider the evidence applicable to each count as though it were the only accusation before you for consideration, and you must state your findings as to each count in a separate verdict, uninfluenced by the fact that your verdict as to any other count or counts is in favor of or against the defendant. The defendant may be found guilty or not guilty of any or all of the offenses charged, depending on the evidence and the weight you give it under the court's instructions. I'm about to instruct you on the law that you are to apply to the charges in the defense, but before doing so, I am going to define a few words and phrases that appear more than once in the elements of the charges and the defense that follow. The words and phrases being defined are bolded in the written copy of the instructions you will be receiving. You should use these definitions for these words and phrases in your deliberation. Attempted means that the defendant did an act which was a substantial step toward and more than mere preparation for causing the result, and that the defendant did that act with intent to cause that result. There are several forms of bodily harm relevant to some of the charges or the defense. Bodily harm means physical pain or injury, illness, or any impairment of a person's physical condition. Substantial bodily harm means bodily harm that involves a temporary but substantial disfigurement, that causes a temporary but substantial loss or impairment of the function of any bodily member or organ, or that causes a fracture of any bodily member. Great bodily harm means bodily injury that creates a high probability of death, that causes serious permanent disfigurement, or that causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. To cause death, causing death, or caused the death means that the defendant's act or acts were a substantial causal factor in causing the death of George Floyd. The defendant is criminally liable for all the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were the natural result of the defendant's acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability. However, the defendant is not criminally liable if a superseding cause caused the death. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not otherwise have occurred. To know, to have knowledge, or knew requires only that the defendant believes that the specified facts exist. Intentionally or intentional means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal, and that are set forth after the word intentionally or intentional. With intent that, with intent to, or intended, means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause that result. It is not necessary that the defendant have this intent in advance. The necessary intent can develop during the commission of the act. Police officer means an employee of a law enforcement agency who is licensed by the Board of Peace Officer Standards and Training, charged with the prevention and detection of crime and the enforcement of the general criminal laws of the state of Minnesota, and who has the full power of arrest. A law enforcement agency is a unit of state or local government that is authorized by law to grant full powers of arrest and to charge a person with the duties of preventing and detecting crime and enforcing the general criminal laws of the state of Minnesota. The Minneapolis Police Department is a law enforcement agency for these purposes. The definition of any word or phrase with a specific legal meaning that appears only once in the elements or the defenses will be defined where it appears later in these instructions. The defendant is charged in count 1 with murder in the second degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another without intent to cause the death of any person, while committing or attempting to commit a felony offense, is guilty of the crime of murder in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the second degree while committing a felony are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant at the time of causing the death of George Floyd was committing or attempting to commit the felony offense of assault in the third degree. It is not necessary for the state to prove the defendant had an intent to kill George Floyd, but it must prove that the defendant committed or attempted to commit the underlying felony of assault in the third degree. There are two elements of assault in the third degree. First, defendant assaulted George Floyd. Assault is the intentional infliction of bodily harm upon another, or the attempt to inflict bodily harm upon another. The intentional infliction of bodily harm requires proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that this act resulted in bodily harm. Second, defendant inflicted substantial bodily harm on George Floyd. It is not necessary for the state to prove that the defendant intended to inflict substantial bodily harm or knew that his actions would inflict substantial bodily harm. Only that the defendant intended to commit the assault and that George Floyd sustained substantial bodily harm as a result of the assault. Fourth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of the elements have not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons according to the instructions below that are listed on page 8 under the heading Liability for Crimes of Another. The defendant is charged in count 2 with murder in the third degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life, but without intent to cause the death of any person, is guilty of murder in the third degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the third degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant caused the death of George Floyd by an intentional act that was eminently dangerous to other persons. A person commits an act eminently dangerous to others when the act is highly likely to cause death. Fourth element, defendant acted with a mental state consisting of reckless disregard for human life. The defendant's act may not have been specifically intended to cause death and may not have been specifically directed at the particular person whose death occurred, but it must have been committed with a conscious indifference to the loss of life that the eminently dangerous act could cause. Fifth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the instructions that are listed on page 8, under the heading Liability for Crimes of Another. The defendant is charged in count 3 with manslaughter in the second degree in connection with the death of George Floyd. Under Minnesota law, whoever by culpable negligence, whereby he creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another person, causes the death of another, is guilty of murder of manslaughter in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of manslaughter in the second degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. Culpable negligence is intentional conduct that the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. Third element, the defendant's act took place on or about May 25, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the following instruction on liability for crimes of another. The following instructions apply to all three of the charges I've just given you. The defendant is guilty of a crime committed by another person or persons only if the defendant has played an intentional role in aiding the commission of that crime and made no reasonable effort to prevent the crime before it was committed. Intentional role includes intentionally aiding, advising, hiring, counseling, conspiring with, or procuring another to commit the crime. The defendant's presence or actions constitute intentionally aiding only if first the defendant knew another person or persons were going to commit or were committing a crime. Second, the defendant intended that his presence or actions aid the commission of that crime. If the defendant intentionally aided another person or persons in committing a crime, or intentionally advised, hired, counseled, conspired with, or otherwise procured the other person or persons to commit it, the defendant is also guilty of any other crime the other person or persons commit while trying to commit the intended crime, if that other crime was reasonably foreseeable to the defendant as a probable consequence of trying to commit the intended crime. The defendant is guilty of the crime under this theory of intentionally aiding in the commission of a crime by another person or persons only if the other person or persons commit the crime. The defendant is not guilty for aiding, advising, hiring, counseling, conspiring, or otherwise procuring the commission of one of the charged crimes unless that crime is actually committed. The defendant, or the state has the burden of proving beyond a reasonable doubt that the defendant intentionally aided another person in committing the charged crime. No crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer, and without regard to the officer's own subjective state of mind, intentions, or motivations. The defendant is not guilty of a crime if he used force as authorized by law. To prove guilt, the state must prove beyond a reasonable doubt that the defendant's use of force was not authorized by law. You are the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. In determining believability and weight of testimony, you may take into consideration the witness's interest or lack of interest in the outcome of the case.
Obviously, the feed coming out of Minneapolis frozen for a moment. We did note that there were flakes in the air when Alex Prost was reporting live, so they are having typical Minneapolis spring weather as these closing arguments are set to begin. Perhaps that's why the feed has been temporarily frozen. We'll go back to it just as soon as we get it again. I want to bring in Terry Austin of the Law and Crime Network. Terry was with us for the opening statements, and we expect Obviously, this morning, Terry, the prosecution to go first, followed by the defense, and perhaps a quick rebuttal from the prosecution. And we also expect that video that the nation and the world has now seen to be played, at least in part, again. And we all remember in that opening statement that the prosecution said, you can believe your eyes, that it's homicide, it's murder. You can believe your eyes. And they're expected to make a very similar closing argument here this morning.
I would exactly expect that, David, because they want to make sure they tie the whole case together, starting with the opening, obviously referring to some of the witnesses. But the whole point of the prosecution is you can believe this video. It was unnecessary force, and absolutely the cause of death was the restraint on top of George Floyd. One thing I also wanted to mention, you see that the Judge Cahill is doing these jury instructions in Minnesota under Rule 26. You can do the instructions before the closing. I think some of our viewers might have been thinking that the closings would be first, but here the judge is opting to give the jury instructions before the closings.
Yeah, those viewers, including those of us here on the desk in New York, Terry, we were wondering, we thought it was a chance that he would conduct it this way, deliver instructions first, and that is what he has done this morning. It's believed that perhaps he'll go back for a recap of those instructions after the closings. Terry, thank you. I know you're going to be here all morning long. I want to bring in Terry Moran, who's covered the courts for us for years. And Terry, you were listening in as Judge Cahill was carefully instructing the jurors there. Take us through some of what struck you as far as those instructions. We know they are pivotal in this case and that they had not been made public until obviously this morning, and that both the prosecution and the defense also are the only ones privy to what the judge might say ahead of time. And Terry, we'll get your thoughts in just a moment because we do have the feedback. Let's listen to the judge.
This evidence is not to be used as evidence of the character of George Floyd. During the testimony of some witnesses, the parties introduced demonstrative exhibits in the form of charts, summaries, and animated videos. This information was presented to assist you as an aid in your understanding of the witness's testimony and to help explain the facts disclosed by the records, other documents, testimony, and other evidence that was received during the trial. If any chart, summary, or animated video is not consistent with the facts or figures shown by evidence in the case as you find them, you should disregard the chart or summary or animated video and determine the facts from the underlying evidence. Earlier during these instructions, I defined certain words and phrases, and you are to use those definitions in your deliberations. If I have not defined a word or phrase, you should apply the common, ordinary meaning of that word or phrase. During this trial, I have ruled on objections to certain testimony and exhibits. You must not concern yourself with the reasons for the rulings, since they are controlled by rules of evidence. By admitting into evidence testimony and exhibits as to which objection was made, I did not intend to indicate the weight to be given such testimony and evidence. You are not to speculate as to possible answers to questions I did not require to be answered. You are to disregard all evidence and statements of attorneys that I have ordered stricken or have told you to disregard. And with that, I'd ask you to put your instructions under your chair as we listen to the closing arguments of counsel. Is the state ready to proceed with closing?
Yes, sir.
Mr. Slisher, you may proceed.
May it please the court, counsel, members of the jury. His name was George Perry Floyd Jr., and he was born on October 14, 1973, in Fayetteville, North Carolina. To his parents, George Floyd Sr. and Larcinia Jones Floyd, Sissy, the matriarch. Now, you met George Floyd's brother, Philonis, and you heard all about Sissy Floyd. She was George Floyd's mom. She was the mom of the house. She was the mom of the neighborhood. And you heard about the special bond that she and George Floyd shared during his life. You heard about their relationship, how he would always take time, special attention to be with his mother, how he would still cuddle with her in the fetal position. You heard that. And from George Floyd's brother, you learned all about George's childhood. And during his time growing up in that house, George Floyd was surrounded by people he knew, people who knew him, people he recognized, a familiar face to pick out in the crowd. People need that. George Floyd was surrounded by people he cared about and who cared about him throughout his life, throughout his childhood in that house, through his adolescence, into his adulthood. On May 25, 2020, George Floyd died, face down on the pavement, right on 38th in Chicago, in Minneapolis. Nine minutes and 29 seconds. 9 minutes and 29 seconds. During this time, George Floyd struggled, desperate to breathe, to make enough room in his chest to breathe. But the force was too much. He was trapped. He was trapped with the unyielding pavement underneath him, as unyielding as the men who held him down, pushing him. A knee to the neck, a knee to the back, twisting his fingers, holding his legs for 9 minutes and 29 seconds, the defendant's weight on him. The lungs in his chest unable to expand because there wasn't enough room to breathe. George Floyd tried. He pushed his bare shoulder against the pavement to lift himself, to give his chest, to give his lungs enough room in his chest to breathe, with the pavement tearing into his bare skin. As he desperately pushed with his knuckles to make space so he'd have room to breathe, the pavement lacerating his knuckles. The defendant stayed on top of him for 9 minutes and 29 seconds. So desperate to breathe, he pushed with his face, to lift himself, to open his chest, to give his lungs room to breathe. The pavement tearing into his skin, George Floyd losing strength. Not superhuman strength. There was no superhuman strength that day. There's no superhuman strength because there's no such thing as a superhuman. Those exist in comic books. And 38th in Chicago is a very real place. Not superhumans. Only humans. Just a human, just a man, lying on the pavement, being pressed upon, desperately crying out. A grown man crying out for his mother. A human being. And in that time, and in that place, while he was surrounded in life by people he knew him, faces he could pick out, there was no one there he knew. He was surrounded by strangers. Strangers, all of them. 9 minutes and 29 seconds. He's surrounded by strangers, not a familiar face to say his final words. But he did say them to someone. He said them to someone who he did not know by name but he knew him from the uniform he wore and the badge he wore. And he called him Mr. Officer. That's what he called him, Mr. Officer. Mr. Officer would help. We call the police when we need help. And he pleaded with Mr. Officer. George Floyd's final words on May 25, 2020 were, "Please, I can't breathe." And he said those words to Mr. Officer. He said those words to the defendant. He asked for help with his very last breath. But Mr. Officer did not help. The defendant did not help. He stayed on top of him, continued to push him down, to grind his knees, to twist his hand, to twist his fingers into the handcuffs that bound him, looking at him, staring down at times the horrified bystanders who had gathered and watched this unfold. The motto of the Minneapolis Police Department is to protect with courage and to serve with compassion. But George Floyd was not a threat to anyone. He wasn't trying to hurt anyone. He wasn't trying to do anything to anyone. Facing George Floyd that day, that did not require 1 ounce of courage, and none was shown on that day. No courage was required. All that was required was a little compassion. And none was shown on that day. George Floyd said, "I'm not trying to win." This was a call about a counterfeit $20 bill. All that was required was some compassion. Humans need that. People need that. But more fundamental than that, and more practical at that time, in that place, what George Floyd needed was some oxygen. That's what he needed. He needed to breathe. Because people need that. Humans need that. To breathe. And he said that. And the defendant heard him say that. Over and over. He heard him, but he just didn't listen. He continued to push him down, to grind into him, to shimmy, to twist his hand for 9 minutes and 29 seconds. He begged, George Floyd begged until he could speak no more, and the defendant continued this assault. When he was unable to speak, the defendant continued. When he was unable to breathe, the defendant continued beyond the point that he had a pulse. Beyond the point that he had a pulse, the defendant continued this assault. 9 minutes and 29 seconds. When the ambulance arrived, the ambulance was here, and the defendant continued. He stayed on top of him. He would not get up. He would not let up. He stayed on him, grinding into him, continuing to twist his fingers, to hold him down. He had no pulse. He was not breathing. He was not responsive, and the defendant had to know what was right beneath him. Right beneath him. You saw the video. You saw the point when the ambulance arrived, and finally, after a paramedic got out, and the defendant still did not get up, and the paramedic tapped him, and finally the defendant got up, and they lifted Mr. Floyd onto that gurney, and you saw the way he was not, there was nothing there. His head had to be held to prevent it from falling to the ground. He was completely limp. The defendant had to know that. He was there. He was on top of him. And he was on top of him. On top of him. Sometimes you ask for the truth, sometimes you insist on the truth. And the truth is the defendant was on top of him for 9 minutes and 29 seconds. And he had to know. He had to know. Yeah. The medical examiner would find the cause of George Floyd's death to be cardiopulmonary arrest, complicating law enforcement subdual, restraint, and neck compression. Well, what you saw the defendant and the other officers doing to George Floyd caused his death. The medical examiner ruled the death a homicide, death at the hands of another. What the defendant did to George Floyd killed him. It was ruled a homicide. The defendant is charged with murder. He's charged with murder and he's charged with manslaughter. The defendant at the time was a police officer. Okay? It may be hard. It may be hard for any of you to imagine a police officer doing something like this. Remember, in jury selection, and we talked about bias and we talked about setting biases and preconceived notions behind. Well, imagining a police officer committing a crime might be the most difficult thing you have to set aside, because that's just not the way we think of police officers. We trust the police. We trust the police to help us. We believe the police are going to respond to our call for help. We believe they're going to listen to us. And this is strong. This runs deep. I'd say it's difficult to set this aside. I want you to consider that even after, with the bystanders, after they saw what they saw, after they saw this shocking display of abuse of police power and a man murdered in front of them, Genevieve Hansen, she called the police. Donald Williams, he saw this. You heard him. He testified. He called the police. A 9-year-old. Judea. What did she suggest? We need to call the police on the police. That's our expectation. Even after seeing this, even after witnessing this, our expectation is that the police are going to help. And with reason, and with good reason, right? Because policing is a most noble profession. It is. It is. And to be very clear, this case is called the State of Minnesota versus Derek Chauvin. This case is not called the State of Minnesota versus the police. It is not. Policing is a noble profession, and it is a profession. You met several Minneapolis police officers during this trial. You met them. They took the stand. They testified. Make no mistake, this is not a prosecution of the police. It is a prosecution of the defendant. And there's nothing worse for good police than a bad police who doesn't follow the rules, who doesn't follow procedure, who doesn't follow training, who ignores the policies of the department, the motto of the department: to protect with courage, to serve with compassion. Chief Arredondo, the chief of police in Minneapolis Police Department, he took the stand and he testified and he told you what that badge that he wears over his heart means. It's a public service. It's a public trust. They're there to help us. It's a professional organization. There are standards. There are rules. There's a code of conduct. There's a use of force policy. There's extensive training. The police are first responders. They're who we call for help, and they help us. They have CPR training. There's more training than simply use of force. There's more to policing than putting handcuffs on people and hauling them away, to be true, right? There's other kinds of training. There's procedural justice. There's crisis intervention training. There's medical training. And there's defensive tactics. And there's de-escalation. All of this training. hundreds of hours of training. You met the people who staff the training center, and they told you, we don't train this. They told you that. The sanctity of life and the protection of the public, those are the cornerstones of the Minneapolis Police Department's use of force policy. The protection of the public, all of the human beings that make up the public. The defendant, he didn't do that because that day his badge just wasn't in the right place. The defendant was a police officer. He was. And again, you need to set aside the notion that it's impossible for a police officer to do something like this. The defendant is on trial not for being a police officer. It's not the state versus the police. He's not on trial for who he was. He's on trial for what he did. That is what he did. That is what he did on that day. 9 minutes and 29 seconds. That is what he did. He didn't follow training, those hundreds of hours of training that he had. He did not follow the department's use of force rules. He did not perform CPR. He knew better. He just didn't do better. He just didn't do better. Remember during opening statement, counsel said that the defendant followed the rules and followed his training. Did you hear evidence of that? Did you hear evidence of that from the stand? Or did you hear something quite different? The chief of police testified. He violated their use of force policy. He violated their de-escalation policy. He violated the duty to render emergency aid. No. You heard the trainer, Lieutenant Mercil. We don't train this. This is not who we are. No. That representation was simply wrong. That's just a story. What the defendant did was not policing. What the defendant did was an assault. I'm going to discuss the law with you in a bit here and explain. The court's already provided you some instructions on second-degree murder, and you know, done in the laws of this state, if you commit a certain level of assault, a felony level assault, and a person dies as a result of your assault, you're guilty of murder. It's as simple as that. And what the defendant did here was a straight-up felony assault. This was not policing. It was unnecessary. It was gratuitous. It was disproportionate. And he did it on purpose. No question. This was not an accident. He did not trip and fall and find himself upon George Floyd's knee and neck. He did what he did on purpose. And it killed George Floyd. That force for 9 minutes and 29 seconds, that killed George Floyd. He betrayed the badge and everything it stood for. It's not how they're trained. It's not following the rules. This is not an anti-police prosecution. It's a pro-police prosecution. The defendant abandoned his values, abandoned the training, and killed a man. And why? Right out in the public, right out in broad daylight, in front of several bystanders as they looked in shock and horror. And why? Well, this all started over a call of an alleged counterfeit $20 bill. But George Floyd's life was taken for something worth far, far less. Far less. You saw the photo. You saw the body language. You can learn a lot about someone by looking at their body language. The defendant facing down that crowd. They were pointing cameras at him, recording him, telling him what to do, challenging his authority. His ego is pride. Not the kind of pride that makes you do better, be better. The kind of ego-based pride. But the defendant was not going to be told what to do. He was not going to let these bystanders tell him what to do. He was going to do what he wanted, how he wanted, for as long as he wanted. And there was nothing they could do about it because he had the authority. He had the power of the badge and the other officers. And the bystanders were powerless. They were powerless to do a thing. The defendant, he chose pride over policing. Charles McMillan, 61 years old, interesting man, right? You remember when he testified, he had the glasses. If any of you in the front row, when he walked by, happened to notice his shoes, if you looked at his shoes, you probably saw your reflection in those shoes, right? He dressed for court like it was the most important day of his life. Interesting man. He was there. He's sort of narrating this horrific scene throughout. You hear him in the video. And he called out to George Floyd. He said, you can't win. You can't win. And George Floyd replied, I'm not trying to win. I'm not trying to win. I'm scared. But the defendant was trying to win. He wasn't going to be told what to do. He wasn't going to take a challenge to his authority. He was trying to win. And George Floyd paid for it with his life. Now, also need to be clear, this is not the trial of George Floyd. George Floyd is not on trial here. You've heard some things about George Floyd, that he struggled with drug addiction, that he was being investigated for allegedly passing a fake $20 bill that there was never any evidence introduced that he knew was fake in the first place. Right? But he is not on trial. He didn't get a trial when he was alive. And he is not on trial here. Defense claims that he was non-compliant. Non-compliant. Well, let's revisit what happened before the 9 minutes and 29 seconds. Before that, it's Memorial Day, right? May 25, 2020, and George Floyd is sitting in a car in the driver's seat with two friends. Now, previously he'd been in Cup Foods. He'd been in the store. He was walking. He was talking. He was breathing. As alive as any person, any human in this room. Back to the car. He's with his friends, and there's a tap at the window. He looks to his left, and a startle. This is what he sees. This is what he sees. Within seconds of the approach, Officer Lane have tapped on the window. Within seconds, he pulls his gun and holds it inches from George Floyd's face and starts shouting profanities. Show me your effing hands. Show me your effing hands. Screaming it. This is within seconds. You can tell a lot about someone by looking at their body language. How does Mr. Floyd look in this photo? Terrified? An officer on the driver's side, an officer on the passenger side. Lane orders Floyd to put his hands on the steering wheel. He does. That's not resistance, that's compliance. Lane orders Floyd to get out of the car. He does. That's not resistance, that's compliance. They order him, they want him handcuffed. He is handcuffed. That's not resistance, that's compliance. And on the handcuffs, you recall the testimony, they weren't properly double locked. And so they continue to ratchet. They're not on correctly, they're on too tight. Throughout, and you listen to the videos, throughout the videos you can hear the sound of those handcuffs ratcheting tighter and tighter. Mr. Floyd is trying to explain to the police that his wrists hurt, impervious to pain. Please. His wrists hurt. No one listens to him. But it continues. They tell him to go over to the Dragon Walk. He goes over to the Dragon Walk. That's not resistance, that's compliance. They ask him to sit down. He